include exchanging information through our networks of intellectual property attachés throughout the world, compare notes, compare information, this possibly do joint démarches with third countries if we have a problem in common, which would often be the case. That kind of a practical thing. And then, I finished by that, there is, but it's another wider chapter, is this new treaty. And I'm not sure when you mentioned anti-counterfeiting, whether you're referring to the anti-counterfeiting action of the bilateral EU-US group, or then there is this new treaty launched, those negotiations have been launched 1 year ago, called ACTA, Anti-Counterfeiting Trade Agreement. The substance of it has been released, the substance of what has been agreed so far, because it's not finished, has been released by both USTR and the EU Commission and all ACTA parties being EU, US, Japan, etc., on the website. So a lot of it is explained, and there is also a customs border chapter, etc. But I mean, I will not summarize here 6 pages.
There have been some criticisms that the ACTA negotiations have been subject to too much secrecy. Mm-hmm. What do you say to the suggestion that the talks should be more open, and that there are concerns that ACTA might result in curtailing free speech rights in the internet by narrowing the fair use doctrine or interfering with whistleblowing or government watchdog activities?
Okay, these are 2 different questions. First, on the principle of secrecy. Well, I know that there is no international trade negotiations happening in public. I mean, there's none of bilateral agreements is happening in public. The WTO negotiations in DDA does not happen in public. So why this one? Well, secondly, and more importantly, we do not own what the other governments are saying. I mean, it's their property. It's their negotiating position. So we can't. No one can say what the others are saying. But what is important, and I want certainly to conclude and insist on that, is that we do feel that, of course, public should be informed, because otherwise you end up with this information, and I will come to your second question. And this is why we have organized 2 widely followed so-called stakeholders meeting, plus on the basis of release of a very comprehensive document of what ACTA has been discussing so far, because it's not finished yet. It's been widely followed. The one I did in Europe, there were, I think, 170 businesses and consumer groups, etc., registered. So it's as democratic as can be and as transparent as can be. Now, as you can imagine, the negotiating parties don't go to ACTA out of the blue. They come with their own background of legislation. In Europe, for instance, we have very strong legislation regarding private life, privacy, etc., data privacy. So it's totally unimaginable that we would change that by going to ACTA. ACTA is about commercial scale counterfeiting piracy. It's not about personal iPods or personal devices. When it comes to customs, for instance, we have de minimis rules, which of course would be applied. So that's very important. The internet chapter specifically has not been addressed yet. So anything you would read or hear about it is totally rumor, because this is the only chapter which we haven't started discussing yet.
What's the essence of the internet chapter?
Well, there is none yet. I mean, the idea is, of course, that we have to address a phenomenon which is an objective phenomenon, is that not only you have piracy on the internet, but you also have counterfeit sales being held by internet. Now, obviously, this didn't exist by the time of TRIPS agreement in '94, certainly not in that magnitude, so you need to address it. How to address it? Clearly, there's conflicting views. On one hand, you will probably have the right holders asking for a bigger control of the internet. It doesn't mean it has to be unreasonable. There are examples in Europe of ways of doing that. And of course, on the other hand, you'll probably have the interest of the internet service providers, the ISPs, who will be willing to do less. And we have to strike a balance between both. But as I said, we haven't reached that. This being, well, no, please.
Well, as a counterfeiting treaty, is there any
Anti-counterfeiting treaty.
Right. Is there any scope for regulating pure information exchange, or is it just the application of labels to products?
I don't understand what you mean by pure information exchange.
Well, there are some fears that the information that is owned or claims to ownership might be restricted, exchange might be restricted, but counterfeiting as a pure concept is not related to information, but rather labels applied to products.
Well, as I've said, we haven't reached that yet, so I have no idea what is going to be the proposal on this one. If you take the most extreme examples of, most extreme no, but the furthest reaching examples of internet regulation attempts, which in Europe have been failed last minute, but what you see in the content of the French draft law, the three-strike rule, that at first you receive an email saying that you are downloading illegal content. This is for piracy, it's not for counterfeiting. Second, you get a registered letter saying that you should stop it, and the third time your internet connection is terminated. By the way, in this project, the right holders did not have the information on who is downloading. They only have an IP address, but they have the address, they have the IP address, anonymous IP address, and on the basis of what is being downloaded, they could ask an authority from the state to issue these warnings. But even then, none of this includes regulating information, so I can't see it coming.
How do you see factors? A couple of weeks ago, maybe it was even last week, the Pirate Bay company in Sweden, I guess, the developers of that peer network were charged with, as far as downloading issues were concerned. Do those things stand up legally as far as the efforts that are being made? I don't know if you can comment officially on it, but when you see efforts like that being made by governments to stop these activities, what's the success ratio of getting actually a company to change its ways when it comes to people who use the technology to download?
Well, as you can imagine, as a European Commission official, which is an executive body, I have no comment to make on a judicial decision taken by a criminal court in one of my member states. I should note also that criminal sanctions for IP is one of the few non-harmonized in Europe issues, so what you may have in one country may be different in another one. But as far as I know, Sweden is a very democratic country, and if people are prosecuted and condemned, it must be on the basis of the criminal law. There is nothing new in the law itself. I mean, since the TRIPS, downloading illegal content on a commercial scale is liable of criminal prosecution. So it's nothing new. Perhaps what is new is that governments actually do it because they see a problem of magnitude, etc.
Well, given we accept that criminal sanctions are appropriate, what about the practical result that still might not stop the piracy if it moves to overseas or to a location that's harder to bring criminal sanctions?
Yeah, then you go back to not to the offer side, but to the demand side, and the French system of three-strike rules, or there are other systems that you could keep your internet connection, but you would have a reduced band width, so that you could have your emails, but basically not download illegal programs. In other words, you have all these solutions. I mean, nothing is perfect. The phenomenon is fairly new. I just take one point. I mean, if you replace the pirated music, say, or pirated films, and you replace that by hard copies, and you go to a store and you steal a few CDs or a few DVDs once, and 2 times, and then 3 times, and the only thing at the 3rd time is that you get banned from the store, is that big? I mean, is that a big of a sanction?
Doesn't seem inappropriate.
But because it's exactly that. Actually, it's even worse, because to be banned from the store, you'd have to steal on a commercial scale, which probably 3 individual CDs would not suffice. So you'd have to steal like hundreds of thousands of CDs.
When you come to...
But that's personal comment, I should say.
Of course.
Sorry.
When you come to the United States, who do you talk with? Is your work done mainly through the trade Representative, or is it through the Department of Commerce? And
it depends. For one, for the EU-US working group, my counterparts were actually located in the OC. It used to be Chris Israel and Wayne Pogue. I understand the position is now being moved to the White House, but has not been fulfilled yet. But that would be my next counterpart for the EU-US working group. And then for international negotiations per se, like ACTA or WTO negotiations, it would be USTR.
And have you had a chance to deal with any of, since the change in the administrations, any new faces as far as you're talking to yet?
I haven't met new faces. No, I haven't. We haven't seen new faces yet. And actually, we're waiting for this administration to make up its mind on ACTA, because we were supposed to resume the negotiations early on this spring, and we understand there was a delay because of the change of administration. We just hope that it won't last too long, because well, you have a dozen countries plus 27 waiting to continue this very important international negotiations.
Yesterday, as we taped this, World Intellectual Property Day took place. It took place on the 26th. And one of the things that were talked about was the world of intellectual property, especially when it comes to, I don't forget where the quote came from, but as far as, I think, using it to help develop more research and development jobs, especially when it comes to green technology. Mm-hmm. What kind of efforts do those mean for a job like yours as far as negotiations are concerned?
It's a very important topic that's coming up, that probably will be discussed in the coming month. It's always the same with IP. You have to strike a balance between, on one hand, encouraging innovation and encouraging it by a promise of reward. On the other hand, limit the monopolies that it de facto, de jure gives. This balance has been achieved in other controversial fields. I'm thinking of access to medicines, where we've changed the TRIPS agreement by making special exceptions to allow compulsory licensing for countries who don't have production facility at home, etc. Obviously, there'll be discussions going around this green technology. The problem is, of course, the green technology is extremely far-reaching, even more than access to medicine, because I don't know, if you are Airbus and you make a fuel reduction system in your planes, is that green technology should be given for free to any country that's willing to have an aerospace industry? I don't think so, but you have these issues, same for automobile industry, same for a lot of industries. So it's an important debate. I mean, in Washington here with 32 degrees, I think that no one can deny the climate change. Well, in April, it's fairly hot, I think.
Well, it is built on a swamp.
One more question we have time for.
Well, you mentioned striking a balance. I think the U.S. has found it difficult to strike a balance between trade with China and deciding whether to apply sanctions for failure to protect IP. Mm-hmm. Is there anything you can say about the European experience with China that might provide and offer a path to solution?
Well, China is, of course, very important. It's important because the magnitude of the trade we have with them, our custom statistics systematically indicate that the majority of the seizures of counterfeit goods, and we're talking of 80 million products, counterfeit products, we're talking about 58% come from China, so it is a problem. Also, domestically in China, we see that our companies are confronted with big problems of access to justice. The requirement to bring evidence in justice is just amazing. And so the magnitude of problem is big. This being said, China has made progress. It's undisputable. Now the question is, has it made progress as much as it could, or should it be encouraged, between inverted commas, to do more? China has a very clear agenda to be #1 in a number of technological fields. I mean, it's officially their policy. You can read it on the Chinese government documents. The question, of course, is will they do that respecting IP? We were not co-actor in the litigation. We were observer in litigation between China and US. It's difficult on enforcement issue to imagine that, of course, one dispute will solve it all. I believe we have to continue a cooperation with China, and we have very big cooperation with China, and it goes from customs cooperation, which is quite